Hi, everyone, and welcome to this latest installment of Pocket Chat. We're here to support the Chicago Bar Association and the Chicago Bar Foundation Task Force on Sustainable Practice of Law and Innovation. A little choked up, a little tongue-tied already. I'm Lynn Grayson. I'm one of the co-chairs of our task force, and I'm the CBA First Vice President this year. And along with my co-chair, Justice Mary Ann Mason, we'd like to welcome you to this Pocket Chat. We're thrilled to have with us today Roya Samargandhi, one of the members of the Modernizing Lawyer Referral and Law Firm Models Committee of our task force. Roya is a managing attorney at Carmel LLC, where she focuses her practice on representing low and moderate income individuals and has a wealth of experience associated with what we're going to talk about today, which is recommendation number 4 of the task force that came out of her committee to develop new or amended rules on alternative fees and fee petitions. This recommendation was put together by her committee, which is comprised of legal professionals who work in a variety of practice settings and who represent a variety of different viewpoints. With that, I'd like to, Roya, turn to you and ask you maybe, can you help us understand what the problem is associated with this issue and how we aim to solve it based upon the work of the committee?
Sure. Well, thanks for having me today. One of the biggest impediments to the legal industry today is the fact that the consumer and small business market has a need for legal services, but that the market is largely opaque when it comes to pricing. And so you have people who have a legal issue and who may otherwise actually be able to afford legal help, but because they don't know how long their case is going to last and how much it's going to cost, they ultimately find that legal services are going to be unaffordable. And so that problem exists largely because attorneys rely so heavily on the billable hour. And in addition to lacking transparency and cost certainty for clients, it also misaligns the incentives between the client and the attorney. The attorneys, the whole basis of their economy and their financial windfall, I'll say, from cases is taking longer time, billing more hours, whereas the client's looking solely to achieve their objective to resolve their matter, whatever the case may be. And so using the billable hour causes a tension between what the attorney wants to achieve and what the client wants to achieve. In contrast, when you're offering alternative billing arrangements like fixed fee or subscription models, which have become the norm in other industries, it really allows the consumer to do a value proposition compensation or consideration, excuse me. So in other industries like IT services or graphic design, more savvy and sophisticated consumers are saying to those firms, here's the problem and here's the solution. Tell me how much it's going to cost up front to get this solution. And that way they can decide whether the price that's being offered really is valuable and worth it from the get-go. And legal services really shouldn't be any different. And you have attorneys, including the Chicago Bar Foundation's own Justice Entrepreneurs Project, of which I'm an alumni, where you have attorneys that have recognized that these alternative fee arrangements really are better both for the client and for the firm and the attorney. Not only is the client getting that transparency and that price certainty and predictability, but it's better cash flow for me. My clients have agreed to a cost up front. They have deemed it affordable and valuable, and they've been able to budget and allocate their financial resources to pay that up front. And so I don't have to worry about chasing my clients down for hours that I've billed after the fact and after the issue has been resolved. Not surprisingly, legal consumers have really overwhelmingly reacted positively to these alternative fee arrangements. But the issue is why they're not being more broadly used. And that's because the rules of professional conduct don't make it clear for not only attorneys, but for judges that these alternative fee arrangements are ethical and appropriate. And so ultimately what ends up happening is that attorneys fall back to using the billable hour because they don't want to take the risk of any uncertainty that comes with the alternative fee arrangements.
So that makes a lot of sense to me in terms of what you said. And one thing I was reminded, it's not exactly on point, but it's come up time and time again on our pocket chats. And when we were working with the task force, the motivation behind the task force is really twofold, as you appreciate. We certainly want to improve the practice of law for the clients we serve and for those that need access to justice, and make that as accessible and suitable and appropriate as possible. We also want to improve the practice for lawyers. There are a lot of lawyers out there that are working, that need work, that we need to connect with clients, and we need to figure out how to make those practices more sustainable. So when I think about the work of the task force, I'm so excited about our work and this recommendation in particular, because I kind of view it as a win-win. I think it's a better option for a client to choose, because I think it provides certainty and gives them options when it comes to the finances of seeking and having a lawyer. But it also is a better financial model, I think, for a lawyer too. So I
would say, there was a 2015 study that was conducted that found that 2/3 of defendants in civil cases are pro se. They've elected to handle their case, on their own. And so what that means for us as attorneys is there is a huge untapped market of people who we could be serving, who we could be marketing to. And I truly believe, and my firm has shown, that offering these alternative fee arrangements brings some of that market share in. So really it is about, the benefit for the attorney as well, and making sure that our supply is meeting the demand.
Right. So given what you've said, how does the work of your committee and the recommendation that you've proposed, how does that make things better?
So the comment to Rule 1.5 is really intended to achieve two different goals. The first is to clarify that fee arrangements based on arrangements other than the hourly rate are permissible under the rule. The second goal is to encourage the broader use of these alternative fee arrangements by providing concrete examples within the comment to clarify for attorneys how they can work and what types of forms that they can take. Additionally, the comment or the proposed new Supreme Court rule with regard to fee petitions is meant to clarify, not only for attorneys but also for judges who are ruling on these fee petitions, that any fee agreement that is reasonable under the circumstances as required by Rule 1.5 is or can be the basis for a fee petition without needing time-based entries to support it, except under limited circumstances, which we've set forth in the proposed rule. So the rule would explicitly allow lawyers to use other types of fee arrangements outside of the billable hour for their fee petitions, and our intention being that it would encourage more lawyers to actually offer those alternative fee arrangements, thus improving access to affordable legal assistance for the legal consumer.
And with that background, can you talk a little bit specifically about what the committee has recommended and how you would propose to implement this change and incorporate the proposal in front to the Illinois Supreme Court?
So like I mentioned, we are proposing a specific rule, a comment to Rule 1.5, again, explicitly authorizing and encouraging the use of fee arrangements not based on the hourly rate. And then the additional Supreme Court rule that we're recommending would explicitly authorize that these fee petitions can be based on alternative fee arrangements as opposed to the billable hour.
So that makes sense to me in terms of regulatory reform and what's actually going into the proposal that soon will be submitted later this year in September to the Illinois Supreme Court. But, given your practice area and the wealth of experience you've got here dealing with these fee petitions, can you give us a couple of examples so we better understand, why this matters and how it's come up in your practice?
So I have had several opportunities or, instances where I've brought a fee petition. More often than not, I'm seeking for the adverse party to actually reimburse my client for the fees paid to me. So it may be under a petition for rule, contempt proceeding, or it just may be brought specifically under a statute. I have had judges that have required me, despite me, the arrangement and clearly under my engagement agreement with my client being a flat fee, have had me go back and recreate time-based entries, knowing that they're not, they weren't made contemporaneously. And to me, that questions the reliability of them. But, it became clear to me that the judges don't know how to assess the reasonableness of my fees unless they could see a time entry. And so, the intention is I'm providing a value to my client. And again, I set those fees so that they would be reasonable under 1.5. To have to go back and recreate time entries diminishes that value, and it is an inefficient and frankly inappropriate way to evaluate whether what I'm asking for in terms of my fee petition is reasonable or not. I have had judges where I've brought fee petitions and they've seen that I have offered fixed fee or subscription-based fees. They've actually commented on the value add. So those judges that are somewhat more innovative or more educated on these alternative fee arrangements have reacted really positively when they've seen that arrangement be put into use between my client and myself. And so I've had one judge actually remark in open court that it was a very beneficial arrangement between my client and I in bringing a petition for rule, and understanding that the way that my fees were based was based on the value and the result and the objective that I was able to achieve for my client, as opposed to just how many hours I was able to bill.
So, I mean, the other thing that I'm very cognizant of when you talk about what's gone on and the experience you've had with these fee petitions is, the situation around this recommendation so epitomizes what we're trying to do with the task force. You've got traditional thinking of how law should be practiced, how law has been practiced. When you try to do something different, even though it's better for the client, even though the client wants it and it's good for the lawyer, we've got some barriers there, whether it's educational, in some cases rule-oriented barriers that keep us from doing what everybody agrees is the right thing. And that's exactly what the task force is intended to do, which is to, create a better situation for the clients we serve and the lawyers that trust us to have the right rules in place so that they can make a living and practice law too. I so appreciate your participation on this pocket chat today. Is there anything else you'd like to share with us about the work of the committee or this recommendation that you've not already contributed?
I'm just really honored to be part of it. I love being part of kind of the innovation in the legal field. I was brought up in very traditional firms, and so kind of seeing the evolution of the practice is something I'm really excited about, and I'm just so pleased to be a part of it.
Well, thank you very much. We're very pleased to have you a part of the task force. We appreciate all of your work and your participation in joining us today for another pocket chat. And with that, on behalf of the Chicago Bar Association and the Chicago Bar Foundation, we'd like to thank you for viewing this pocket chat. We encourage you to take a look at the final report, view other podcasts that are available at the Chicago Bar Foundation's website at chicagobarfoundation.org, and learn more about the final report and the recommendations that will be submitted to the Illinois Supreme Court later this year in September. We invite you again to view additional pocket chats. Each recommendation has an associated pocket chat with it, and we encourage you to take a look at those and also to participate in our public comment period, which will get kicked off later in July, and let us know what you think about our final report and the recommendations we've made to our Illinois Supreme Court. It's intended to help all of us as lawyers, help the community and the clients we serve. So please, we invite you to take a look at it, make recommendations, and give us your feedback. Thank you very much for viewing this, and thank you for your participation.